So, Judge Gray, we'll go ahead and get started. Again, thanks for providing that talk in the first place. It's really, really relevant and germane, especially right now with a lot of the work that the Center for Courts has been doing nationally around reasonable efforts and judicial trainings of training judges around reasonable efforts. We're gearing up to do some work with attorneys as well. So for me personally, it's always fruitful to hear from a seasoned judge how these kinds of decisions are made, not only technically, but sort of from a value perspective, what's driving this analysis and this decision-making process. So thank you for articulating that. You just bring a wealth of experience that's really invaluable to the national conversation, so thank you. And we have a great turnout today, actually a ton of people, which is really nice to be able to hear a little bit more from you. So let me just get out of the way, Judge, and invite you to respond maybe to this prompt. What is the thing that you today, it's January 4th, 2021, I think you gave that talk a little less than a year ago. What's the thing that you want to stick out to us today? What's the thing that we should carry with us over the next, weeks, months, or even year in our practice?
So I first like to start off by saying good afternoon to everyone who's joined in. And I think, so the thing that stands out the most, shortly after I did the talk, we went into pandemic mode. And I think what I would encourage people to think about in their daily work is that even though we're in the pandemic, the talk that I gave is still relevant. So in a pandemic, when people are losing jobs, they're losing housing, they're having difficulty finding food for some people, pandemic, hurricanes, natural disasters all roll in together. And there has been quite a bit of conversation about the safety of children during the pandemic and concern that children are not being protected. What I encourage people to do is, as much as possible, to push back on jumping to conclusions and, in the process, not paying attention to what the law requires. I think even in the pandemic, we still have to abide by reasonable efforts. And I was, when I first came on the bench in 1984, I was trained by a judge from Kentucky, Judge Fitzgerald, who preached reasonable efforts to us as new judges. And I took that to heart. And I've been very clear in the years that I've been on the bench that our first obligation is to try to maintain family integrity, keep children with their families, if at all possible, while maintaining their safety. And far too often, I thought that there were many times when we reacted, sort of knee-jerk reaction, without really doing the analysis of the individual cases to determine that there was indeed a safety risk that couldn't be addressed in a way that did not require the traumatization of children by removal of them from their parents, their homes, their schools, their siblings, their aunts and uncles, their grandparents. And what I would encourage people to remember is that even as we're trying to do good, even as we're trying to protect children, there's trauma involved in the removal. And while we may be able to mitigate that trauma by interventions that we make, what we know through the research is it is far better, if we can, to never have the children experience that additional trauma, the trauma over and above the abuse or neglect that they've already suffered. And so I would just want people to remember that removal in and of itself is traumatic, and that we cannot always undo that trauma of removal, even as much as we would like to, and if we can, we should try to avoid it. So I want people to take that with them every day. And the other thing that I have told people is that I try to make my decisions using the law and also with some compassion. And what I would always say, if this were me, if this was my family, what would I want done? And if it wasn't what we were doing in the case, then I would think we should do something else. And so I encourage people to also think about, from the human perspective, what would you want done if it were if you were in a similar situation? And that's sometimes difficult because people don't see themselves ever being in that position. But, pandemics happen, and lots of people who never thought they would be in positions or in positions today that they wouldn't have imagined a year ago.
Yeah. Several things stand out to me there. Before I jump too deep into them, let me just say to the 57 folks that have joined us for the interview today, if you have any questions that you want to ask Judge Gray directly, feel free to do that. There's 3 ways that you can do it. It doesn't matter to me which of them you choose. The first thing you can do is just type it directly into the chat. I'm got an eye on the chat, and my colleagues Stephanie and Adria do it as well. So we'll just read them off to Judge Gray so that everyone can hear and enjoy the benefit of her response. If you don't want to type it in the chat, you can just talk over the phone. Even while I'm talking, you could just interrupt me and I'll be quiet. And you can talk. Don't worry about being rude. Trust me, it's the least offensive thing that will happen to me today, I'm sure. So just start talking. The third thing that you could do if you wanted to be fancy is on the top of your screen there's an icon of a person with their hand raised. If you click that, it'll tell me that your hand is raised, and then we can just call on you verbally and you could ask your question over the phone. So 3 ways to do it. Probably the easiest one is just to shoot your question into the chat box, and we'll pick it up throughout the conversation. Judge Gray, one of the things that, there's a couple things that I would like to hear your perspective on. One of the things I heard you say, it's implicit, it's implicit and explicit. It sort of comes to the surface sometimes in your comments, but it always seems to be present even when you're not speaking directly to it. It's making reasonable efforts, findings that are detailed and child-specific. In other words, I hear you pushing a lot on the idea of ask questions about this child and this family. You talked about, can this child be placed with a relative that's near, like literally geographically, who's close by? What have you done, agencies, specifically in order to either avoid removal or return the child home? Like you said, at each hearing you're asking, what can we do to return home? So that level of specificity and detail around the child really resonates to me as an attorney with regard to these types of findings. There's a question here, I promise, because a lot of what we see in court orders are these kind of well, they're form. You've seen them before yourself, these kind of form reasonable efforts findings, right? It's literally like a checkbox. So my question is this. What would you say to the judge who says, if you're, by the way, if you're not talking with a question, if you could just mute your phone, that would be helpful to cut back on some of the background noise. Thanks. So my question, Judge Gray, is this. What would you say to the judge who says to you, I want to make more detailed and specific findings like you're describing, Judge Gray, but we have this whole court system and culture. Literally, we have forms that we use. It's really, I'm really going to be the squeaky wheel here. How do I get people on board with this more, what I'm going to call robust, reasonable efforts analysis? So what advice would you give me if I'm that judge?
That's an interesting question. So first I want to say, when I first went on the bench, the forms, when I was first trained about reasonable efforts, the forms I'm familiar with because we had them in Louisiana. And there was a checkbox, and that was being done, and that was being recommended by everyone who thought this is the way to get judges to do what they need to do and meet their requirements. But what became obvious was that we were just checking the box. We weren't even going through the motion of even getting the background information. Talk about the background noise. We weren't getting the background information. We were just checking the boxes. And I decided that what I thought the law required was an individual finding for individual families, and that there should not be this all families are alike. So if that is what is the way I'm functioning, that necessarily means I cannot do a checkbox. I have to have an in-depth discussion with the workers, with the lawyers and the family about what's going on. And I would say to the judge, what I did, I guess some may consider me a bulldog, a bulldozer. And I remember there was one of my colleagues who talked about, sometimes, there's collaboration, and sometimes you need to be able to collaborate. And so once I decided that for me this is what was required by the law, I decided to do it no matter how much pain it caused the lawyers or the workers. And true, when you start, you are going to get a lot of pushback. But if in fact you believe it is the right thing to do and it is your obligation as a judge, at some point you say to people, this is what the law requires that I do. I'm going to uphold the law. That's what I took an oath to do. And I'm sorry if it's inconvenient, but this is what I believe I'm required to do. I know it is what I owe to the children and families, and I'm going to make these findings. Now, there are a lot of things that go with that. So if you're a judge who has lots of cases, so the judges will sometimes say, I have a lot of cases. I can't really afford to do that. Well, I go back to what my dad told me when I was growing up and I had a chore, and if I half did the chore, he would say, well, if you did it right in the first place, you wouldn't have to do it a second time. So if you get it right, it will become easier to do. And so we don't have many times to get it right for these children. We really only have, I went blank. We really only have, we should consider ourselves as having one opportunity to get it right. And we need to maximize that opportunity. And for every child, that requires an in-depth hearing. I remember going through some recommendations that the National Council, I believe, had in the resource guidelines, talked about the amount of time that should be devoted for different types of hearings. I found myself doing more than even they recommended for my hearings. And so, I had the luxury at the end of having a small caseload, but even when I had a large caseload, I just dug my heels in and said, this is what I have to do.
Yeah, that doesn't surprise me. Knowing what I know about you, that's the character of your answer. And for those of you that are working with CIP projects around reasonable efforts or prevention, there's a lot of different projects that implicate reasonable efforts. I just want to highlight kind of the structure of Judge Gray's answer. Like, you have in her, in my opinion, the paradigm example of a judicial champion, someone who has, in a lot of ways, the courage, the fortitude, the tenacity to move forward based on conviction and legal accuracy, for that matter. So there's something important about Judge Gray's experience, sort of structurally, and how this shift can happen. So I just want to highlight that. Judge, can you tell me a story about a time when you either made a no reasonable efforts finding or used the chance of a no reasonable efforts finding to move the case forward, or maybe a time when another attorney raised the issue or requested that you make a no reasonable efforts finding, and sort of tell us how that played out, and what lessons can we draw from using a no reasonable efforts finding as a way to reduce this trauma that you're talking about, or at least mitigate it throughout the life of a case?
So I would say that, first of all, we should recognize everyone is afraid of a no reasonable efforts finding. And so when a lawyer, for example, who represents a parent or a child is requesting a no reasonable efforts finding, the agency attorney, in my experience, sort of bends over backwards to try to avoid that. And so one of the things, again, I keep harking back to this judge in Kentucky that I learned from. So what the judge would recommend it, and I use it as a tool as well, is that rather than make a reasonable efforts finding, you indicate to the agency, if these things don't occur, I will have no choice. And so what I do is I set it for another hearing. I indicate the problems that I have or the issues that need to be addressed, and I indicate that when we come back, if these are not addressed, then a no reasonable efforts finding is going to be made. And so a lot of times it's around contacting relatives who may be out of state. Sometimes it's around even a placement or keeping a child in the same school, which really shouldn't be an issue, but sometimes that happens. And so for things like that, it's fairly easy to have a conversation about how we can do things to mitigate and make sure that that reasonable efforts is not no reasonable efforts finding is not made. And I find that it is a great tool to use in helping to move the case for getting services, for looking for dad, looking for grandparents, finding alternative things for children to be involved in. Almost any part of a case, whether it's for a parent or a child, if you want something to happen that is not happening, if you start talking about making a no reasonable efforts finding, people respond to that. And I think it's a great tool. I think so. The people at the Children's Bureau has criticized judges for not using the no reasonable efforts finding more effectively. And so I think as judges going forward, using that as a tool, I think will be really meaningful as we try to talk about how we change the child welfare system to one in the future that really does what we think the child welfare system ought to do, and that is remove as few children as possible, but also making sure that they are in safe homes, safe communities, and working in our communities to build supports for families in a way that we've talked about but have not been able to do yet.
Yeah, thank you. What I love about your comments is you're connecting, well, there's lots of things, but one of them is that you're connecting the idea of reasonable efforts and safety analysis and the trauma of removal. So another way, what I might say, my version of what you're saying, or just saying back to you what you've already said, is something like the reasonable efforts finding is a tool that you can use to push the litigants to remove the threat as opposed to the child, right? That's just sort of my shorthand version of what you're saying, and I just think that's a super, super important point, and for me, at least from a legal perspective, really resonates. I have one question that came in the chat here. Kelly Linscott wants to know whether, in your opinion, there are any key elements that you see that are routinely omitted in providing or documenting reasonable efforts.
Key elements. So I criticize the department a lot for not documenting, period. So they don't do, in my opinion, they don't do a good job of documenting the number of times they may reach out to a parent. So if a parent is missing, they hasn't been in contact with the department and the department hasn't been able to find them for a month or 2 months. So I will ask, so what did you do to try to find the parent, the mother, the father? And they will say, well, we called them, we sent a letter, and I will say, well, how many times? And so there's a failure to at least appreciate and understand that every time you make a call or you attempt to contact that person, from my perspective at least, it's important to document that. I remember having a conversation with someone in the department who said, if it's not documented, then it didn't happen. So what I try to express to the worker is, this is your proof of your efforts. When you're able to go to your records and say, on this day and at this time, I did such and such. And the other thing that I require as a part of my being able to assess the documentation is I require the workers to bring their files to court, which is another thing that caused great angst for the department. Sometimes, obviously, the records are 3 volumes or whatever, but in a case, in a hearing in which we need to dig back into the record, if they don't have the record there, that means we have to reset the case and bring it back. So I require the workers to bring the records to court, and whenever there's an issue about whether or not something happened, then I will allow the worker time to go into the record and find out. So to me, documentation of all of the efforts, no matter how minor they are, is important. So, in a lot of our cases, the dad, unfortunately, the dad is missing. The dad has not been involved. The dad's relatives may not be actively involved in the case, and since we don't know where the dad is, sometimes don't know who the dad is, we can't engage that side of the family. But it's important to me that, for example, the department is documenting their efforts, one, to find out who the dad is, find out where the dad is, find out about the dad's relatives, and figure out whether or not, while the dad hadn't been involved, just like the foster parent, stranger foster parent hadn't been involved either, the dad hadn't been involved, maybe this is a time that we can call on, if not the dad, his relatives, his parents or sisters or aunts, to take care of the child. And so to always document that, and I think that's one of the places where we fall short, looking at the paternal side of the family and documenting that.
Great, thanks. Any other questions, by the way, feel free to type into the chat. Judge, I'm sensitive to my prompt to keep you on all afternoon, and we're coming up against the time. So we have about 5 or 6 minutes left before I break my promise. So I want to just make sure we have enough time for folks to ask questions. So again, if you want to just throw a question in the chat or raise your hand or just start talking, that's totally fine. I mean, it's probably not the last question I have, but if I have you for 6 more minutes, the last question that I would like to ask is, and you've mentioned this a little bit, but I want to press on it a bit more with you, because you know and I know that it's a hang-up for a lot of judges. You mentioned that, I think the way you said it was, everybody's afraid of a no reasonable efforts finding. And I don't want to lose sight of the fact that we're not talking about just the legal mechanism of a reasonable efforts or no reasonable efforts finding, but we're talking about as it relates to a way to reduce or maybe even eliminate the trauma of removal. I just want to, it's important, I know from your perspective, it's important not to lose those two things. It's not this sort of sterile legal mechanism. It's deeply related
Correct.
to the way people's lives play out. So I wonder if you might say something a little bit specifically to the judicial fear that we often see. So in my experience, and if I'm wrong, please correct me, in my experience, oftentimes judges don't know what will really happen if they make a no reasonable efforts finding. For example, the federal law, you have 60 days from removal to make your reasonable efforts finding under the federal statute, but under state statute, the no reasonable efforts finding can have different implications. And there's a funding implication, but it does not mean it's not the case that a no reasonable efforts finding means that a child won't get services or won't get food or something like that. So could you just say a word or two specifically to judges who are specifically afraid of making a no reasonable efforts finding because of what it may or may not do?
So, Andy, I'm not sure that I agree that the judges are afraid of making a no reasonable efforts finding. I think the fear, whether you make a reasonable efforts finding or no reasonable efforts finding, is that the fear is if you allow the child to stay home, allow the child to remain with the parent, not authorize removal, the fear is that the child, something bad will happen to the child, right? And so I think, I'm not sure it's the fear of a no reasonable efforts finding, but I think judges are really concerned about, so if I let this child go home, bad things could happen. Well, as a matter of fact, no one has the ability to see the future or what's going to happen. And so what I say is, what I try to do is make the best decision that I can with the information that I have at the moment. The information that I have at the moment, which is why I push the worker on the stand or the lawyers or whoever to provide everything that they have, all the information that they have, so that when I make the decision, I have that, and my decision is based on the best information I can get. I can't make a decision based on something that the worker might have known, but she didn't tell me, because I have had that experience of someone saying, well, the worker had more information she could have given you. And I say, well, she didn't, or he didn't. I just had what they gave me, and that's how I decide. So I worry that, that is the concern that a lot of judges have. Obviously, I don't want a child to be hurt on my watch either. And so, I think that getting information, pushing people for knowing something about knowing everything they can about the family and the family situation, is important, and when we make the decision, the best one we can make at the time, and we have to live with that. No one wants to have a child die on their watch. I don't want to, I've had the experience of having children in foster care who've been hurt far worse than they were, the harm that happened that brought them into foster care. And so, there's harm in foster care as well. And I think for a lot of people, they forget that. Children get hurt in foster care. And so while we need it, it is not the panacea necessarily, but we need it for some children. We don't need it for all the children who might come to our attention. And so what I encourage judges to do is just be courageous, get the facts, push for the facts, push for the information, and then make the decision. And, don't be afraid to make a no reasonable efforts finding, because like Andrew said, the state is not necessarily going to lose money, and even if they lose federal money, it doesn't free them of their obligation to provide state funds to make sure the child is maintained in foster care. All it means is that they are not able to draw down federal money, but they still have to provide for that child through the state funds in foster care. So, obviously every state probably needs the foster care dollars from the feds and don't want to lose them, but they don't get freed up from providing appropriate, adequate care for children who we've removed from their parents just because we make a no reasonable efforts finding.
Yeah, that's helpful. And just to add to that, Judge Gray, that connects up to what you said earlier. To put it bluntly, it's not the judge's problem. The federal funding drawdown dollars, right? Like, it's not part of the reasonable efforts analysis isn't whether or not this will impact the agency's ability to draw down federal funds, right? Like, your obligation is to analyze this child in this case. So I just want to make that point clear as well, because I think it's a salient one. Judge, you know me, I could probably go on like this for another hour, but I want to respect your time. What do you want to leave us with? I could ask that question different ways. What should I do tomorrow to start moving in this direction? But I don't want to pin it down too much. So what do you want to leave us with here as a group as we move forward?
So I think I would just take you back to where I started. And I think I would say to everyone, this is not easy work. It's tough work when you deal with the lives of children and families. And what I always encourage us to think about is that we are dealing with young people, and we are really fashioning their future. And so whether their time in foster care is 3 months, 3 weeks, 3 years, hopefully not 3 years, but for some children, unfortunately, it has been that long, we need to understand that we're fashioning what's going to happen to them and the young adults, the young citizens that they're going to be for our future. And we need to do everything that we can to make sure we are ushering out young people in our system who are able to care for themselves, find supports for themselves, and become productive citizens. And to remember that no matter what we do, there's trauma associated with each one of the actions that we take. And our concern is try to minimize that trauma. And when it is inflicted, to figure out what are the best interventions that we can put in place to help young people and families deal with the trauma. And that we are all, I believe, in the field doing the work because we want to have our young people and our families do better. And to remember that for many of them, they need our help. They don't always need us in their lives forever, but they may need us for some period of time, hopefully very short period of time, when they can then be able to be on their own and take care of themselves. And I would also say, don't be afraid to be bold and courageous, because that's what is needed in the work.
That's wonderful. Thank you, Gray, Judge Gray. I really appreciate you got me stewing now. Just that last comment even has my gears turned, so I'll leave it alone. Judge Gray, thank you very, very much for your contribution to this. And I would tell you I was going to say this, but I'm just going to say it. I hope you don't get mad at me. Everyone on the line should know that this is Judge Gray's first day of retirement, which is exactly why we got her to work for us. And we knew she had time off. Well, we had her join us on this call. So if you'll join me, if you could just join me in thanking her for her decades of service and congratulating her on her accomplishments and esteemed career. Judge Gray, frankly, it's been an honor to work with you over the years, and I look forward to working with you more in the future. So thank you for that. The rest of you, if you have any other questions and you want to put them in the chat, you can. We can always send the transcript to Judge Gray and then send out her responses as well. I'll hang in the room for about 3 or 4 more minutes if anyone has any follow-up questions, but that's all we have for today. Again, Judge Gray, thank you for everything. You're free to go and enjoy your retirement and your first day off here. Hopefully it's something nice. And for the rest of you, thanks for joining us, and we'll see you next month.
Thank you, Andy, and I look forward to seeing you on the road somewhere else.
Yeah, my pleasure. Me too.
Bye-bye, everyone. Thanks.